you post a photo, a family gathering, a birthday party, a weekend trip, nothing unusual, nothing controversial, nothing related to your lawsuit. Just a normal moment shared online. But somewhere, an insurance investigator sees it, a defense attorney saves it, and suddenly, a post that seemed completely harmless becomes evidence in a case worth thousands or even millions of dollars. The frightening part: many injury victims never realize the damage until it's too late. In today's world, some of the strongest personal injury claims can be weakened by a single social media post. Not because the victim was lying, but because online content can tell a very different story than reality. And the tactics used to find and use those posts may surprise you. When most people think about personal injury lawsuits, they focus on the obvious evidence: medical records, police reports, photographs from the accident scene, witness statements, expert testimony. These are the things people expect attorneys and insurance companies to examine. What many don't expect is that one of the most important pieces of evidence may already be sitting on their social media profile. A photo, a video, a comment, a status update, something posted in seconds that can remain accessible for years. And in modern personal injury litigation, social media has become a powerful investigative tool. Why? Because injury claims often revolve around a central question: how has the injury affected the victim's life? The answer can influence nearly every aspect of a case: medical treatment, lost income, pain and suffering, physical limitations, future damages. The greater the impact, the greater the potential value of the claim. Naturally, insurance companies and defense attorneys want to verify those claims, and social media offers a window into a person's daily activities. Imagine someone files a lawsuit alleging a serious back injury after a car accident. They describe ongoing pain, limited mobility, and difficulty participating in normal activities. Then investigators discover photos showing the person hiking, dancing, lifting heavy objects, or participating in recreational sports. At first glance, those images may appear damaging. The defense may argue that the activities are inconsistent with the claimed injuries. But here's where things become complicated. Photos don't always tell the full story. A picture captures a moment. It doesn't reveal what happened before the image was taken. It doesn't show whether the person experienced pain afterward. It doesn't reveal medication use, physical limitations, or medical advice. Yet despite these limitations, social media content can still be extremely persuasive, because lawsuits are not only about facts, they're also about perception. And perception can influence how evidence is interpreted. This is why experienced personal injury attorneys often warn clients to be cautious about their online activity during litigation. Not because every post is harmful, but because almost any post can be misunderstood. Consider another example. A victim claims emotional distress following a serious accident. Months later, they appear smiling in photographs from a family celebration. The defense may attempt to argue that the person is emotionally unaffected. Of course, anyone who has experienced hardship understands that a smile in a photograph does not necessarily reflect someone's overall condition. People continue living their lives. They attend family events, celebrate milestones, spend time with loved ones, yet social media frequently presents only the highlights, and those highlights can create narratives that don't accurately reflect reality. Another issue involves comments and conversations. Many people casually discuss their accidents online. They respond to questions from friends, share updates, express frustrations. Sometimes they speculate about fault, injuries, or legal claims. These statements can become important evidence. A seemingly harmless comment made months earlier may later be compared against medical records, deposition testimony, or statements given to insurance companies. Even minor inconsistencies can attract attention, and once inconsistencies appear, defense attorneys often explore them aggressively. But perhaps the most surprising aspect of social media investigations is how extensive they can become. Insurance companies don't always focus solely on recent posts. They may review months or even years of publicly available content, photographs, videos, locations, check-ins, tagged posts, comments from friends. The goal is simple: find information that can challenge the claim. And sometimes the most damaging evidence isn't created after the accident at all. Sometimes it comes from something posted long before the injury occurred, something that can raise questions about medical history, prior injuries, physical abilities, or credibility. And when those questions begin surfacing, an injury claim can suddenly become much more difficult to prove than anyone expected. The biggest misconception about social media and injury claims is that only dishonest people have something to worry about. In reality, many of the posts that create legal problems are made by completely honest individuals. They aren't trying to hide anything. They aren't committing fraud. They're simply living their lives. And that's exactly what makes these situations so dangerous, because personal injury lawsuits are often built around context. A photograph rarely provides that context. A short video rarely tells the entire story. A single comment rarely explains the full circumstances, yet those pieces of content can still become powerful evidence. Imagine an injury victim attends a family wedding. They spend most of the evening sitting due to pain. They leave early because of discomfort. The next day, they're dealing with symptoms and medical limitations. But the photo posted online captures only one moment, a smile on the dance floor. To an insurance company or defense attorney, that image may become an opportunity, not necessarily proof, but an opportunity. An opportunity to argue that the injuries are less severe than claimed, an opportunity to challenge credibility, an opportunity to create doubt. And in personal injury litigation, doubt can be incredibly valuable to the defense. That's because injury claims are often evaluated through the lens of consistency. Do the medical records match the victim's statements? Do witness accounts support the timeline? Do social media posts align with the claimed limitations? The more consistent the evidence appears, the stronger the case becomes. The more inconsistencies emerge, the more complicated the claim becomes. This doesn't mean injury victims must disappear from social media, nor does it mean every post will damage a lawsuit. But it does mean people should understand that online activity may be viewed differently in a legal setting than it is among friends and family. What feels like a harmless update can take on an entirely different meaning when examined by attorneys looking for weaknesses in a claim. That's why many legal professionals advise clients to think carefully before posting during active litigation, not out of fear, out of awareness. Because once content is published online, controlling how others interpret it becomes much more difficult. And deleting posts after a dispute begins can create its own legal complications, particularly if questions arise about preserving potential evidence. Ultimately, the lesson is simple. Social media is not inherently dangerous, but it is rarely private in the way many people assume. Insurance investigators, defense attorneys, opposing experts all may examine publicly available content in search of information that supports their case. And sometimes, the post that causes the most damage isn't a dramatic admission or a shocking photograph. It's an ordinary moment that appears inconsistent when removed from its original context. That's why some injury claims are weakened not by what actually happened, but by how what happened appears online. And in a world where nearly every moment can be shared instantly, understanding that difference has become more important than ever. Now we'd like to hear from you. Do you think insurance companies should be allowed to use social media posts as evidence in injury lawsuits? Or do you believe too much can be taken out of context? Share your thoughts in the comments below. It's a debate that becomes more relevant every year as more of our lives move online. And if you enjoy learning about personal injury law, insurance investigations, legal strategies, and the hidden factors that can influence a lawsuit, subscribe and turn on notifications. Every week, we uncover the real-world legal issues that often determine who wins, who loses, and why.